So this will give you the grounds upon which to make a successful defence. These points will form the main points of your framework in your argument for your defence, and you have to prove at least one or more of these points, as well as the other points that I gave you. That's a deeper layer, that's a harder layer to get to, but under abuse of process, there are also 3 points that you can prove there as well. They are harder. These ones are easier to prove, especially in your own immediate defence, in light of the facts of the case before you, if you don't wish to step outside that into a jurisdictional challenge type situation. Right? So even in your standard proceedings, what I want to read to you from here under summary judgments, in the Nexus Lexis Concise English Legal Dictionary 4th edition, right, will actually give you the main points to structure your case around. And then I will also show you some considerations. So you'll have your main grounds upon which to mount a successful defence, and also some further subtleties or considerations that you can bring forward as well, under the type of judgment that is administered, the discretionary judgment that is actually administered as a summary judgment. So the type of judgment that you get through the summary judgment system is a discretionary verdict or a discretionary judgment. So there are some considerations that you can take into account as well under that form of judgment, which will also give you some main points that you can then try to prove and hit, and some of those points will directly challenge the magistrate himself or the court system itself, right? So you need to get your shit straight on that, but those considerations cut in deeper again. But these 4 points here are what you have to show, and the preceding points about what the court will actually convict on are the things that you also can disprove, right? These are the things that they have to prove in order to convict you, and I'll also show you the things that you have to prove in order to trigger a positive verdict from their process, right? This is within their process, and through these things, I think those of you that wish to challenge jurisdiction will also find that if you prove one of these points through a direct challenge to jurisdiction, you have also that benefit of actually proving your argument within their process, right, which they can't deny, because these are the points that you have to hit in order to trigger a positive response in your favour, right? And these are the points that that the prosecution will try to hit in order to trigger a positive response in their favour. So I'll read this out to you, listen carefully. Summary judgment, a discretionary verdict. Right, now you might just gloss over that term, but because they mention it down the bottom again as one of the things to research cross-reference under discretionary judgment, abuse of process and frivolous and vexatious are the other 2 things that they tell you to look up in here, the definitions of, right? So you don't discredit that terminology right there, man, because it shows a sort of adjudication that's being delivered. A discretionary verdict given in favour, so this is summary judgment, a discretionary verdict given in favour of the plaintiff, right, the witness against you or the prosecution, where there is evidence of the fact upon which the claim is based. So they have to actually provide evidence of the fact. Evidence of the fact. Let that term stick into your mind. They have to provide evidence of the fact upon which the claim is based, and the defendant appears to have no real defence to the plaintiff's claims. So that's the second point. If they can prove that you appear to have no real defence to the plaintiff's claims, for example, uniform civil procedure rules. That's interesting that they go there. Commercial code. 2005, New South Wales, 13.1, Supreme Court, General Civil Procedure, Rules 2005, Victoria, reference 22.02. Right, so those are the two places that they go to substantiate the fact that if they can prove that the defendant appears to have no real defence to the plaintiff's claim, the process will rule in favour of the plaintiff. If the plaintiff can provide evidence of the fact upon which the claim is based, then once again the process will rule in favour of the plaintiff. Now, this is us. This is what you need. So those are the things you have to disprove that they will try to prove. These are the things that you need to prove in your own defence, right? These 4 points that are coming up. Or in favour of the defendant. So a discretionary verdict given in favour of the plaintiff will be on those two grounds, primarily, right? Primarily, that's what they will try to establish. That's why to look at their brief will show specifically the evidence that they have to bring forth in order to establish the grounds, the claim, the fact upon which the claim is based. The fact. They have to establish by evidence the fact of it. Right? But this is in your favour. So a discretionary verdict in favour of the defendant where the plaintiff has no reasonable action, no reasonable cause of action. Right? So that's the first thing you need to prove. That the plaintiff who's bringing the case against you, number one, has no reasonable course of action, right, against what you've done. If you can show that you've committed no crime, then what reasonable course of action can they further pursue against you? Any action further than that becomes unreasonable, which you can also show and prove the unreasonableness of it. So that's the first thing you need to prove in your defence as one of your main points. If you choose to take that point, right? No reason, and that will, if you can prove that, that will result in the process giving a discretionary verdict in your favour, in favour of the defendant. 2, the proceedings are frivolous or vexatious. So if you can prove that by proceeding with the case against you, that it is actually frivolous, meaning it's a waste of time and money, or vexatious, vexing your person, right? Vexing your actual person. I will read what those things actually mean too, frivolous and vexatious. Right, they seem to come under one heading, so I'll read those out for you. Let's find that now, because if you can prove that, then you also once again trigger a positive response from their process. So I'm sure that leaves a fair bit of room for some of you who wish to challenge the authority and jurisdiction of the Magistrates Court. That leaves a fair bit of room for you to do so. So, frivolous or vexatious. Sorry I'm taking so long with this. I wasn't going to look that up, but we will look it up anyway, because it needs to be understood, obviously. Frivolous and vexatious, unsupported in law. So if it's frivolous and vexatious, you can prove that by showing that it's unsupported in law. disclosing no cause of action. So they're not actually showing any cause for their action against you. Groundless, for example. So once again, the grounds for which they are trying to proceed against you are no grounds at all. If you can prove that, then you've actually got them on being frivolous and vexatious, which will trigger from the process a positive response, a discretionary verdict in favour of the defendant, or it should do. And if it doesn't, well, then they've actually opened themselves to possible contempt of process, of the court process. If you can prove that, well, then you can actually sue them personally and have everything against you dismissed and expunged. Now it gives Day versus Victorian Railway 1949, 78 CLR 62912 91 semicolon 23 ALJR 48. The phrase is generally used with respect to a statement of claim intended to commence legal proceedings. A court may refuse to allow an action to proceed if it considers the action to be frivolous and vexatious. So once again, Daniel Vincent did the right thing by calling out that the court was being vexatious toward him in proceeding, because it didn't make that judgment of its own accord. High Court Rules 2004, Commonwealth, reference 6.07, Federal Court Rules, Commonwealth 020, reference 2. Uniform Civil Procedure Rules 2005, New South Wales, reference 4.15. Also see abuse of process, right? That's what I was saying. Cause of action, statement of claim, stay of proceedings, vexatious and oppressive, vexatious litigant. So you can further see the grounds upon which you can dispute that point under those definitions as well. So back to here. So the second point was an abuse of process. The proceedings are frivolous or vexatious. So if you can prove that, then you can seek the process by you proving that, and also on top of that disproving what the plaintiff has brought against you. Otherwise, the judge will still weigh the plaintiff's case against yours if you can't thoroughly disprove their case, and yet you make a strong case on one of these behalves. The magistrate will have to weigh the decision, but you have a definite right then to seek a discretionary verdict in your favour if you prove one of these points. So if you can prove it's vexatious or frivolous, if you can prove that there is no reasonable cause of action, that the plaintiff has no reasonable cause of action against you, and thirdly, or an abuse of the process of the court. So if you can prove that it is an abuse of process, which is what I read out for you, the definition, and gave you the points, the main points that you needed to prove to trigger a positive response in that respect as well. If you can prove that, right, which is a deeper layer, I showed you that is actually harder than these first couple of points, right? But if you can prove that, abuse of the process of the court, then you also have grounds for a favourable decision, a favourable discretionary verdict. Or fourthly, there is no attendance by or on behalf of the plaintiff at a hearing. So if the actual person on the charge sheet who's bringing the charges against you doesn't show up, you can move to have the case dismissed and a favourable discretionary verdict given on your behalf on those grounds. So don't overlook that. If one of the cops or the main witness against you that should be mentioned, registered on your charge sheet or statement of facts, certainly on your charge sheet, if that person is not present at the time of your trial, well, then you can move straight away to have it dismissed on those grounds, because that's what it says. That's their procedure, right? So those are the four things you need to hit in your own defence. At least one of those things you need to prove substantially in order to trigger a favourable response from their process. And at the same time, you need to consider the two main points that the plaintiff or the prosecution will be trying to bring against you. And you have to consider how you might then answer those points and rebut them, or show the distortion of the fact that they are distorting evidence, because they have to provide evidence of the fact. So if you can show that they are trying to manipulate the facts by distorting the evidence, and you can show the evidence in its true light, and I think that's what a lot of the people have tried to do in the past. But at the same time, you need to prove one of these other points in your favour, right? Not just try to attack their evidence and the fact that they are distorting the facts by manipulating the evidence or distorting the evidence or putting the evidence, or just even ignoring the evidence. So if you can show that and then show one of these points, either that the plaintiff has no reasonable cause of action, right? If you can show that their action against you through the proceedings is unreasonable in bringing you to this point, in bringing you to trial, bringing you to these proceedings, show that they had no reasonable that they have no reasonable course of action. Has no reasonable. So if what you think that they've done to you is unreasonable, then you need to try and prove why. The processes are frivolous or vexatious. You can see that there's a fair bit of ground there in which you can actually make a defence on your behalf. Are an abuse of the process of the court. That's very specific, what you need to hit. That's what I covered in the last video for those, if you want to use that in your defence. Or no attendance on behalf of the plaintiff at the hearing, which would make it too easy, right? If you're just trying to beat their process without making a direct or maybe even see if you can prove that the defendant is not actually there, the plaintiff is not actually there. That's interesting. Because even though I was standing in front of the magistrate in my fourth hearing, standing in front of him, the living man in flesh and blood, directly in his eyesight, directly in his hearing, actually talking with him, he said that he would still put me down as a non-attendance because I was not complying with his specific direction at that point in approaching the microphone to be heard, because I thought he was trying to lure me into approaching the bar, and he may have done so thereby, but he actually said that he would put a warrant out for my arrest on the grounds of non-attendance if I didn't come forward another step or two so that I could be heard clearly and recorded clearly by the microphone. And then he gave me some time to think about it when I refused to consent, and I discussed it with the people, and they seemed to consider that it was not a direct appeal to approach the bar, so I ended up going back in and approaching the microphone close enough. But he showed me that he was actually willing to disacknowledge my bodily presence because I wasn't willing to comply with their process. Well, there's a process here of individuals as well, of the plaintiff. And if the plaintiff was an officer of the court, then that plaintiff is not there by process if that plaintiff is not an actually properly sworn member of the court. On what grounds is he there? So that's actually a way, if you're looking at a jurisdictional challenge, that is a way to use that clause. On what grounds is he there? Is he just a private corporate entity, not an actual officer of the court? Has he sworn the correct oath to make him a constitutional officer of the court? Or is he just a contracted entity, contracted security? So is he actually even there, according to their process? Because even though I was there in the flesh and blood, because I wouldn't comply with their process, though the magistrate Cook was going to put a warrant out for my arrest, and they had some big boys waiting outside the door, man, to try and enforce that warrant if I was going to try and push that point. That's really interesting, right? That's really fucking interesting. But those are the 4 points that you need to hit, as well as try and defend or counter whatever sort of evidence they try to bring forward to prove the fact of the claim, and also to show that you do have a real defence to the plaintiff's claim. Because that's what they will try to do, is try to make it look like you have no real defence to the plaintiff's claim. So you have to show that you have a real defence, a real lawful defence. Right, if you're going to counter those points. So now I'd like to come to the next part, which is the finer considerations that you can also use in looking at discretionary judgment and judicial discretion. So I'll go simply first to discretionary judgment and read that definition for you, and then I will come back to the finer points. There's another 4 points that I've actually listed that once again become the main points of your defence if you're going to actually try to challenge them on any of these grounds and use these grounds as an argument structured into your defence, right? So this once again forms, but these are considerations within the main framework of the actual grounds, your main grounds of defence, which I just actually, the 4 points that I've just finished going through with you a couple of times. I'm sorry to repeat myself. I'm sorry, I don't mean to repeat myself over and over, but I'm trying to get it clear that I don't muddle it either, that I present it and say the words so that people can understand clearly. So a discretionary judgment, and this is a sort of judgment that is delivered by the Magistrates Court, a judgment made in the exercise of the power of a judicial discretion. Appellate courts are reluctant to substitute their own opinion for discretionary judgments unless the court below, right, so the appellate court in this case is the Supreme Court, and this, what they're saying is that they will not, they don't like to look at these things on appeal. They don't like to overturn a discretionary judgment unless the court below acted on a wrong principle of law. So the only way you're going to really get one of these things overturned is to prove that the court below, being the Magistrates Court, below the Appellate Court, which is the Supreme Court, which has the certiorari certiorari power to not only to review and to subpoena and acquire all documentation regarding the hearing that's being reviewed, but also to refuse to look at the hearing. And on these are the grounds, and on according to this, a discretionary judgment is a judgment that they are reluctant to substitute their own opinion for, i.e. their own judgment, right? So they don't even want to bring it up for your right of appeal in the Supreme Court if it's been made as a discretionary judgment, right? As judicial part of as the power under the power of judicial discretion, which is what the Magistrates Court magistrate exercises, right? They are the powers, summary powers. It said under summary judgment, right? That it acts under discretionary powers. So, unless the court below has acted on a wrong principle of law. Now you can hone in on that by going and looking at judicial discretion, which it also tells you to check the definition of underneath. And that statement is actually found in Commonwealth versus Reeve, 1949, steady, 47 CLR 410, 1949, ALR 561, 1949, HCA 22, House versus R, 1936, 55 CLR 499, 1936, HC 40. And then it also says see right of appeal as of right, appeal by leave, judicial discretion. So now under judicial discretion, these will give you considerations that you can also add to your main grounds. And if you can prove one of these considerations, you also then have the right to appeal whatever the outcome of the summary verdict is, the discretionary verdict is in the summary tribunal room. Right, so I'll read the whole definition and then I'll point out the 4 points that you need to hit. The power of a judge to exercise personal notion of fairness. So this is what judicial discretion is. This is what the actual magistrate is using in his adjudication of the case. This is the power that he is exercising. Power of a judge to exercise a personal notion of fairness guided by principles and rules of law. An exercise of judicial discretion does not involve the application of strict rule of law, but involves the weighing, so it's more like a court that mixes law and equity, right? But involves the weighing of various competing factors and making a determination according to what is fair, just, or otherwise consistent with public policy. That's interesting. So these are the things that actually weigh on his judgment, that he has to prove that in considering the various competing factors, both of law, his own personal notion of fairness, the principles of rules of law, which are supposed to guide those personal notions of fairness too, the weighing of various competing factors, he has to prove that he has weighed those factors and made a determination fairly, that it is fair, right? So these are the things that you have to disprove, that his determination is not fair. That it's just, right? Meaning it is actually, can be justified by the law, and it is just in the sight of God too, the spiritual law. right? That it is not an immoral or unjust decision in a spiritual sense, under the spiritual nature of the law, or otherwise consistent with public policy. Well, that is a fairly vague terminology and definition to use, right? So what is the public policy concerning your matter? You might wish to look into that and see whether he's judging by that and whether you think that is also fair and just, right? Matters falling within the scope of judicial discretion are not subject to review except where it can be shown that the judge, these are the four things you've got to prove. One, to review it, but these are also finer points of consideration that you can, I don't mean to make hand signs, that you can actually make, finer points of consideration that you can make during your trial in establishing the other main points. If you see that one of these points is presenting itself, you may wish to hone in on one of these considerations. And in fact, you probably should, if you believe that you're going to get a negatory verdict from the magistrate and you wish to challenge it openly and you wish to actually challenge it by appeal in the Supreme Court, you need to actually show one of these things. And if you can actually bring that out and put it on record during the trial, that would be much to your favour. So, 1, the judge acted upon a wrong principle. So you need to prove that the principle that he acted on in delivering his determination was a wrong principle. 2, failed to take all relevant factors into account. Right, so that actually leaves you quite a bit of room to consider what is relevant in your defence. And then make sure he takes those relevant things into account when he's making his determination. And if you show that he has failed to take all relevant factors, man. So if he's just, decided he wants to overlook something because he doesn't like it because it's common law or whatever, right? You can prove that he has actually is grounds to directly oppose his determination. 3, took account of irrelevant factors. So if he's actually making a mountain out of a molehill, if he actually takes into account factors that are not relevant to your case and you can show that those factors are irrelevant to your case before him, then you have grounds again to directly challenge his determination under a judicial discretion and to directly appeal it in the appellate court. 4, reached a decision no other reasonable judge acting on the same facts would have reached. So that's where I guess case law and precedents would really help you. Because if you can find what a reasonable decision is on your facts, and if the judge exceeds that or does not reach a decision or reaches a decision that no other reasonable judge would make, right? So there is, once again, the clause of reasonableness coming into it. So you need to consider what is reasonable and find examples of reasonableness in dealing with the facts and the decision that was made in light of those facts and the facts that were reached. That's interesting too. So if you can actually prove some of these points, they are also facts that are reached. If he just decides to completely overlook any of those facts that are reached, right, substantiated in the trial, right, within the court process, then he's in trouble.